Yes.
For pronouncement of judgment, item 37.
Learned student examined the record, evaluated the reasoning of the register, and concluded that the order was not supported by sufficient material particulars. We find no perversity or legal infirmity in their conclusion. The autonomy of cooperative institutions must be harmonized with statutory supervision. Harmonious feature not by mechanical equivalent, but by written, evidence-based interpretation. In the present case, the registrar's order does not disclose the degree of analysis required to sustain the drastic consequences of input. The interference by the learned citizen is there to play. For the reasons and upon an independent reappraisal of the fiscal scheme and the record, we affirm the judgment and order dated 31/8/2024. The writ appeal fails and is accordingly dismissed. No order is to post.
Adjournment request, if any, from item number 1 to 11.
Lordship, at numbers 1, 2, and 3, a letter has been circulated on behalf of the Forest Department. We want some time to get updated instructions.
Adjournment slip has been circulated sometimes in April.
27 April.
In respect to item number 8, dusty affidavit has been filed. That may be called for the filing.
What do you want?
The dusty affidavit has been filed today. That may be called for in the court.
What is this? Let it be called out. Let it be called out. If you don't want adjournment,
Well-
you'll see it.
Well.
Yes.
Up to item number 11. From item number 12 to 20, adjournment request. From item number 21 to 29.
May I please?
Yes.
Well, item number 28, kindly may I adjourn for
Item
please.
number
28.
adjournment slip has been circulated. All right.
22nd April.
Okay.
From item number 31 to 36.
May I please, your lordship? Lordship, I beg to mention item number 32, lordship.
32.
32. Lordship, can the matter may be taken up this Thursday or Friday, your lordship?
Now, what has the Supreme Court decided about disability pension?
Lordship.
Why are you asking for Friday? I mean, the matter would be adjourned because the issue is pending consideration before the Supreme Court.
Lordship.
The disability pension,
Lordship.
what should be the component?
Lordship.
Whether the judgment, what is that judgment? Randhir Singh or something. Whether it requires a relook, all this is before Supreme Court. Are you aware of that?
No, your
Then why are you asking time for a week?
lordship. The stay is not granted in this matter, your lordship.
You are for whom?
Lordship for Union of India, your lordship.
Union
Petition,
of India. Very well, we give 2 weeks
lordship.
as prayed for on behalf of the writ petitioner / Union of India and others. The matter is adjourned to give after 2 weeks. Please inform us about the status of the Supreme Court case.
11 March.
Okay.
May it please, your lordship. Lordship, I beg to mention item number 34, lordship.
34, you have circulated the
Yes,
adjournments. All right.
Oblige. May I please, lordship? I beg to mention item
22nd
number
April.
31, lordship.
31.
31, lordship.
Yes, second wife. Pensionary benefits to second wife,
Lordship.
which has been refused. What do you want?
I'm for the second, my lord.
What do you want?
Lordship, adjournment for the day, lordship.
For the day.
For the day, lordship.
At the request of the learned counsel for the appellant, let this matter come up for consideration. Tomorrow is not be possible. Wednesday.
Deeply obliged.
Any other request?
May I please, your lordship? I beg to mention for listing of 2 writ appeal, lordship, for 25th of February, lordship. Lordship, matter is very urgent, lordship.
What is the urgency?
Lordship, actually, petitioners, provincialization of service has withdrawn, lordship.
It has been withdrawn.
Lordship,
When was it withdrawn?
on the month of February 2025.
2025.
Lordship,
You are in February 2026.
Lordship.
Then urgency suddenly after a year.
No, Lordship, matter
No,
was last,
your writ appeal will be listed, but you want it to be heard only on 25th of.
last,
25th of April.
Lordship,
When was the writ petition dismissed?
Lordship, actually matter was last listed on 16th of this
When
month.
was it dismissed? The writ petition, the single judge.
Lordship,
You must have all these facts before you mention for uplisting. We might even ask if the matter is urgent, we might even hear today after notifying it. Get ready with the facts and then come and mention tomorrow. Any question that I ask, even if it pertains to, merits of the case and the urgency, if you satisfy the court immediately,
Lordship,
otherwise we'll send you back for relook.
Lordship,
at your
actually
grounds.
matter was last listed on 16th of
Tomorrow.
this month, but not.
Tomorrow,
it was
come
not
come
raised.
tomorrow fully prepared with the facts as if you are to argue that case.
Lord-
May it please your lordship, I beg pardon and I wish to mention for listing for restoration of an order, your lordship, on 19th of February, your lordship.
Restoration of an order
Indeed, your lordship.
or restoration of a petition.
Yeah, restoration of the writ petition in which order was passed that due to non-prosecution and non-appearance.
So restoration of order is not required. Order has been passed, dismissed for non-prosecution.
Restoration of the writ
And has it been dismissed for what?
for non-prosecution and non-appearance of the advocate, your lordship.
And was it the first time?
It was the first time, your lordship. May kindly, I was here.
We must have examined the merits of the case.
In
And you must not have been appearing for several dates.
No, your lordship, only one single date it was
Anyway.
fixed, your lordship. May kindly be come.
You have filed a restoration
I
application.
have filed, your lordship.
Oh, my brother reminds me that we had dismissed the restoration petition for
No.
second time.
No, your lordship. This is my first. This is
All-
separate, different case.
All right, next week.
Deeply obliged. Deeply obliged.
Daily list for orders item 4.
May it please your lordship.
Yes, Mr. Chaudhary.
My last order which says that, my lord, to serve on the respondent number 6 and 7 the proper address. Can I, my lord, there may be a substituted process of taking steps because getting the proper is not possible.
All right, but what is the reason?
My lord, because they have left the place, my lord. The whole PL is about a person who
All
was
right, and whom are you appearing for?
Lordship, I'm appearing for respondent number 8,
7,
9,
8.
10 and 11.
All right, substituted service of notice, 2
6
dailies, 1 in Assamese, 1 in English, and so and so, requisites.
Obligation.
24th April. Item 5 to 7.
Again, no fresh steps for 7. Why do you do this? 6 and 8.
But I mean 6, my lords. I have a slightly separate submission once your lordship deals with item 5. I'm in item 6, my lord. That's a different
You're in item number?
6, my lord.
All right,
City money. I'll make a submission once your lordship is.
I am in item number 5,
yes.
but item 7, but I'll request this matter to be done by Mr. Fukan. I'll be sitting around behind you.
Doesn't matter.
With your lordship permission, let Fukan argue this matter.
No, but it is not yet ripe for
Oh, it's not,
argument.
it's the
It has
orders.
come for orders.
Oh, I am, sorry, my lord.
Respondents have not been served. Seven has been served.
Servant.
Just a minute, just a
Yes.
minute. 1 second. Respond number, no, 7 also has not been served. No fresh steps have been taken for service of notice on 7. 7, I appear for it. No. Has respond number 6 and 7 been served? Mr. Fukan?
My lord, in the revision, retrieve 138, my lord.
Yes, in the same matter.
Sir, because I don't think the reports come back. 6, 7, 8, my lord. In revision 138.
We are at that only. Just a minute. Let me see. You know, orders and is there. Okay. Governing body is there.
Six and eight.
Governing body goes. No, he must say. Who appears for respond number 7?
Seven in which case?
In first matter, when,
First,
please don't ask questions which are the answer of which is very obvious.
Sorry,
We're looking at the records of the first case.
Pangaya college here, nobody is available.
You appear for whom?
I am for UGC.
Now, the governing body represented by the principal, if 7 has been served, we can hear this. Because he's the secretary of the governing body.
but
Ex
if it
officio.
is,
But the principal has to be here, no?
but if it is not served, I'll request your lordship will not take up, will take a step. So he may be an important, my lord.
But you have not taken any steps.
Yes, ma'am.
पहले order को comply करना है ना? Let the order be complied. नहीं यहाँ पर है ना. They have not done it.
Office for 28th of February.
No fresh steps you have taken.
We'll take today itself, man. We'll take today itself.
लिखिए. And what submissions you had to make?
Lords, in item 6, my lord,
Yes.
mine is an admitted appeal.
Yes.
This was admitted, my lords, on 15th of January 2023. It appears, my lords, item 5 and 7 have got tagged on to my appeal. Now, I'm making a respectful submission, my lord, that my appeal, although it broadly talks about distance education, my lord, but it's somewhat different because what the issue appears in their case is that this is an old degree of 2008. And the question there is whether Pondicherry University, my lord, in terms of section.
Then let it come, we'll hear it together. Wait for a week.
I'm only saying this, my lord, subject to your lordship's pleasure, my lord. The issue in my case is not about territorial in the sense in terms of the statute. For me, this is a second round of litigation. In the first round of litigation, the Sikkim High Court, my lord, protected me and the students up till 2016. I'm not concerned with that historical bit. Subsequent to 2016, there was a fresh slew of notifications and regulations saying that you cannot have examinations outside the state. I don't have study centers. I've shut down my study centers pursuant to the first round, etc. Now, my lords, in my appeal, the question is whether that UGC regulation is valid or not. It's a validity question, my lord. So there were notifications
So
and subject.
therefore, in sum and substance, you say that item number 5 and 7 ought not to be tagged with
Yes,
your
because
case.
I don't have that question of this jurisdiction, the terms of this constituting statute and all that. No, that may not arise for me.
We will like to hear it together if on the next date, the principal or the secretary of the governing body is not present in Mr. Diganta Das case.
Please, no.
Then we'll hear you separately and we'll post that case for another date.
Very well, my lord.
Correct.
Very
So you take steps.
We will take step today itself.
Like, yeah, it appears.
Only it's the one indulgence I'll request, my lord, subject to on the next date, not in case we need some accommodation on the date if a request can be made. That's my only. I don't want to do this matter by
Nobody-
VC, my lord.
nobody
It's not a matter for VC, my lord.
Normally, this court has not declined the request.
No, I
for
know, my lord. I
accommodation.
just want to. I just want to.
Unless it is persistent, it is
No, not at all.
repeatedly.
Just in case, my lord. Just in case.
But we will not remember. You'll have to have somebody here.
Of course. Mr. Das is on record. He
But
will be here.
therefore, why do you take this assurance from the court?
No,
When
I
every
just
day
want
is
to-
a new day.
I just wanted to, my lord,
That's all right.
indicate.
All right. Now that you have not taken time, it's because of the others cases.
Yes, and mine's an admitted appeal.
Yours is very well. Again, the office has reported that no steps have been taken for issuance of notice on respondent number 6 and 8. First up, it appears that respondent number 7, who is the principal cum ex officio secretary of the governing body of the college in question, though has been served, but there is no appearance on his behalf. Let steps be taken during the course of the day. You do it today.
Today itself.
During the course of the day for issuance of notice on response number 6 and 8 by both modes, returnable 3 weeks. The notice on response number 6 and 8 shall be served dusty as well.
Just yours.
And a certificate shall be filed in the registry about such
Yes.
dusty service. No sooner it is effected. Re-notify on so and so date. Along with all these cases.
Very
Sorry,
well. I'm great.
sorry for the inconvenience and sorry to my learned.
No, I was aware, my lord, that this may not go on, my lord, but I was just wondering whether that my attempt was to only bring to your lordship's notice that there might be some distinction, that's all.
On the next day, if you are here, we shall hear you.
Very well.
Yes.
I'm very good.
1st April,
Grateful.
1/4, 1st of April.
Okay. Very good.
Item 5, rest others along with. And you, all orders, you go to him. Every time I'm not going to tell you. Chalo, yeah, don't talk.
Item number 8,
Take it. Okay, what is the report? None appears on behalf of the petitioner, yes, who appears? Where is he? He was here. Mr. Goswami?
item number 8,
क्या करते हैं?
Union.
ठीक है, awaiting the report regarding,
May
sir,
take up, another council is there. Lordship may take up after some time.
awaiting the report of service of notice on respond number 9, the matter is that.
30th March, 30. Item 9,
For respondent number? Awaiting the service of notice on the sole respondent, the matter is adjourned to sir.
30th March.
देख लीजिए, कोई गलत नहीं है।
Item number 10,
Yes.
There's a contempt case, my lord. Petition.
Take it. Let's see what's the order. Take us to the directions of the learned single judge.
My lord, at
Division bench, which
page 23, my lord, para 36. It starts at para 36.
is 23.
Page 23.
The division. The judgment starts from where?
Annexure 1, my lord. Page 11. And the relevant part, my lord, the operative part is at page 23, para 36.
I have not followed the drift of the order.
My lord,
When I say drift of the order, I didn't understand.
my
That
lord,
if it was so conditional, it had to be unlocked, it had to be kept unlocked. That's been disposed of.
so my lord, what has happened here?
What is the direction? What has happened?
My lord, the direction was that it was a conditional order.
Read
my lord.
para 36.
Accordingly, the appellants are directed to file an affidavit in the said two writ petitions, that is 6142 and so and so, that they have made the finalization of NIT dated 1/2025 and resultant contract agreements subservient to and or subject to the decision of this court in WPC so and so.
What is subservient to?
That will be outside of the subject to the decision of these two writ petitions. This appeal is allowed, madam.
Subservient to, I didn't follow.
This is the order, madam.
That's all right, but you have to make me understand, no?
But that is because we had filed two writ petitions. These two writ petitions are pending before the learned single judge.
Yes. The Indian Oil Corporation was directed to file an affidavit. That what has happened in that case?
But that affidavit has not been filed. It was filed because in the last paragraph, my lord.
So their not filing affidavit will be deciding the cases in those writ petitions. We haven't followed. Just let me see what is the issue before the single judge, before the division bench. Just a minute. Well, the respondent.
That's a para 3.
So 1 second. But why had the canteen workers challenge that just challenge those orders passed by the single judge, interfering with the termination of the contract?
My lord, and this appellate court had rightly, my lord, dismissed that. My lord, their contention was that they are the affected parties, and by not letting them work within this contract would be violative of their rights.
No, but the same contractor who was assigned the work,
My lord,
with whom the agreement was entered into, they had been working, these appellants had been working with that contractor.
no, my lord. They had worked with the, and
They had worked with some other contractor.
some other contractor, and there was no any other contractual agreement for the continuity.
And who are you?
I am the contractor, my lord, and the IOCL had been forcing those contractors upon me. So I had to, and they had wrongly terminated my services,
Just a minute.
against which we have come to the.
This capital. Mr. Chaudhary, you had argued, tell us what was the matter?
Milord,
We have not followed it up till now.
Indian Oil Corporation,
Uh,
that's Bongaigaon Refinery. It's situated in a place called Bongaigaon.
Yes.
They have a guest house in Gauhati.
Hmm.
Now the issue is providing catering service to this Gauhati office, Gauhati guest house.
Okay.
Now there was a tender, Milord. Pursuant to tender, my learned friend's client got the contract.
Okay.
Then a dispute arose with regard to utilizing the services of the earlier contract laborer. He said, I'm not inclined to take. He may be right, maybe wrong. That's a different issue, Milord.
No,
Uh,
under the same contract agreement, there some earlier workers wanted to be
No, Milord.
accommodated.
The practice which is being followed in the Gauhati guest house of the BRPL is whosoever may be the contractor, but he will engage the same set of employees. That is the practice. I'm not saying there is any right.
Makes no sense. Yes,
No.
then.
No, but anyway, so his writ petition was allowed.
Hmm.
The learned single judge of this honorable court came to his rescue saying the BRPL authority cannot insist upon him to engage this contract labor.
Correct.
Because during the time the litigation was going on, therefore, my lord, he would get only the period which was remaining.
That's right.
So we gave him,
Unless directed otherwise.
then my lord, we gave him that. He refused to take it.
Why?
He says, I want 2 years from the very beginning.
No, but that's all right. He
Yes.
may be
Then-
unhappy.
then eventually, my lord-
What is the contempt?
No, there is no contempt.
Uh,
The
Is this
perception of the petition, my lord, what had happened,
There is the contempt. This
there is no contempt. Lordship will kindly,
what is this condition which
No, my lord, they say the division bench, my lord, there was an interim order restraining us from settling the contract pursuant to the subsequent tender. So we filed an IA to vacate that order. Learned single judge refused. Then we preferred this appeal. While allowing our appeal, learned single judge says that you will file an affidavit within 2 weeks regarding compliance of the order. That we did. Actually, what had happened, my lord? The matter was heard on 17/7/25 and the order was reserved. Then, my lord, eventually the order was uploaded on 25/7/25. and we filed the affidavit on 2/8/25. So we have filed within 2 weeks as ordered by the court. Only thing is, if we count from the date when the order was reserved, it is not two, it cannot.
No.
That's the only point, my lord. That's the only point.
Yes, Mr.
No, my lord. Things are not factually correct.
That's not correct.
Carrying out the contract.
No, my lord, my lord, just give me 2 minutes. At page 12 of this, my lord, the petition, at para 4, may I read this particular observations of the learned single judge? It says, in view of the aforesaid facts and circumstances, this court is of the opinion that a case for interference is made out. Accordingly, the termination order dated.
And what affidavit you have filed?
My lord, in terms of para 36 direction, we are supposed.
What affidavit?
Yes,
That's
yes.
you will subsequent tender process to have withdrawn.
My lord, will kindly come to
No,
para
madam.
36, my lord. Page 23.
If para 36 would have
Yes.
been intelligible to me, I would not have asked you.
Yes. Accordingly, the appellants are directed to file an affidavit in the aforesaid two writ petitions that they have made the finalization of NIT and resultant contract would be subject to outcome. All that is required was, my lord. In the work order which now will be issued, there a clause would be there. This is subject to the outcome of it. Let us not read the word subservient to, my lord.
Okay,
Subject to.
Subject.
That we have done on second 2/8/2025.
No, so therefore, he is not, his period is over.
His period is over, my lord. Now somebody else is operating. He has challenged that also. That is pending before the learned single.
No, my lord.
This is the case.
Factually, my learned friend is not correct. This order was passed on
He may be correct, he may not. be
17,
correct,
my
but you
lord.
have not been able
My
to
lord, this
make out
order
the-
was uploaded on the 21st, my lord.
We don't understand.
This
We
order
don't
was
find-
uploaded on 21st, my lord, not on 25th.
Where is that? So how does it make a difference?
And then it is 2 weeks.
Just a
No,
minute.
it-
Now,
it-
we don't consider it to be contempt. What do you have to say to this?
It would have ended on 30th.
Contempt
And
is between, Mister, contempt is between the contemners and the court.
My lord.
We find that the order has been complied with.
Yes.
No, my lord, they were late. It was a
Give us the
conditional
date
order.
of the.
Yes,
judgment,
my lord.
sir.
17/7/25 was the date when
There
the
was an oral judgment. Oral judgment was there, no?
no, order
No,
was
my lord,
reserved.
it was a certified, it was a speaking order, my lord.
Order was actually, no, though not strictly CAV, but it was
Ah, but
delivered
then
subsequent.
Let us not. do
Yes,
this.
yes, even I am not wanting
Mr.
lordships
Chaudhary,
to go.
you will be putting.
Yes,
judges
according
and
to
the
us, my
courts-
lord,
The arguments were concluded when?
on
Say
17/7/25.
17/7/2025.
And
When the
according
court-
to us,
When
it
the
was,
court made known the order.
21st, my lord.
but those observations were not
Uploaded on the
very-
21st.
but they applied for the certified copy
No,
on
it is,
37.
that
Just a
is
minute,
irrelevant.
please.
That is irrelevant.
See, haven't you seen, we are not taking it as contempt. Now, no matter how much you may say, we will not initiate a proceeding.
My lord.
Now, when was the judgment pronounced?
17th, actually, the date should be 17/7, but according to us, the order was uploaded on 25/7/25.
Is this fact correct or not?
According
No,
to
ma'am.
him, 21. Let us take 21.
No, 21st.
Uploaded according to you on
25.
25/7/2025.
And according to him, 21.
21st.
Let us take it 21, Milo.
Even then, within 2 weeks. When did you file your affidavit?
Second, 2/8.
The affidavit was supposed to be
2/8,
filed.
and the work order was also issued after that. The requirement was first we'll file an affidavit, then we'll issue the work order, which we did on second.
Take note. By the judgment dated 17/7/2025, a division bench of this court had directed Indian Oil Corporation Limited and 4 others, bracket appellants, in WA number 152 of 2025 to file an affidavit in 2 other writ petitions pending before the learned single judge, namely WPC number 6142 of 2024 and 738 of 2025, that NIT dated 1/2/2025 has been finalized and the resultant contract has been entered into with the concession with a party, which agreement was to be subject to the decision of the court in the aforenoted 2 writ petitions. a contempt, the applicant herein seeks initiation of contempt against the appellant slash against Indian Oil Corporation and its functionaries for not having obeyed the order, not having complied with the operative portion of the judgment regarding filing of affidavit within 2 weeks of the delivery of the judgment. Mr. Ken Chaudhary, who has appeared without any notice having been issued in this contempt petition, submits that notice. Notice, we have issued notice.
Yes, ma'am.
Mr. Ken Chaudhary, who appears on notice, Mr. Ken Chaudhary, learned senior advocate who appears for Indian Oil Corporation and others on notice, submits that though the judgment was pronounced on 17/7/2025, but the same was uploaded on 25/7/2025. The affidavit was filed on 2nd of September. In that case, the affidavit as directed by the division bench was filed on 2nd of September 2025.
August, my lord. 2nd of August.
2nd of August 2025. In that view of the matter, the directions of the learned of the division bench stood complied. The learned counsel in the learned counsel, Mr. R. Sharma, learned senior advocate for the applicant slash petitioner, submits that the judgment was uploaded on 21st of July 2025. Counting the date on which the required affidavit was filed by Indian Oil Corporation and others, even from 21/7/2025, it was within time. Even otherwise, no case has been made out by the applicant for initiation of any proceeding of contempt against the appellants in WA numbers and so on. The application is dismissed.
Authorized.
Item 11.
In item number 8, 9, I just, it is
What is
already
it?
over.
What did I say, Neil?
Eight services complete, 9 services.
Well, can it be, well, there hasn't there in starting the contempt case, that is all, it is fixed on 30 March. Before that,
Okay, which date we have given?
30th March.
30th March. You want a date before that? Give a date before that.
18th March.
You could have requested it from the court master who could have taken consent from us. Don't disturb the proceedings. Yes. Who appears in 11?
Item 11.
May I please, Lordship?
Service is complete.
As per lodging my order, service is complete upon
It
respondent number 3 and 5.
appears from the office notes that the service is complete in all respects. In that matter, this petition, in that view of the matter, this petition is directed to be listed under the appropriate heading of admission on which date?
The next week,
Next week, after 3 weeks.
much obliged.
1st of April. Item 12.
In this case, my learned friend appearing for respondent number 1 will also perhaps appear for the respondent number 3, their husband and wife. No?
I'm appearing for it, but he files a
Again,
There is a connected writ petition.
what is your name?
Maji Alam for respondent number 1.
Mr. So-and-so has appeared for respondent number 1. So-and-so, learned advocate, submits that he shall be filing wakalat on behalf of. Is filing. You are filing.
I'm for 2 lot.
Just a minute. You are filing the wakalat, or have you already filed?
We will file it tomorrow, Lordship. I will file tomorrow, Lordship.
Therefore, you are to file. Wakalatnama on behalf of respondent number 3 by tomorrow. And you,
2 Lordship.
the respondent number 2 already stands represented. In that view of the matter, this case is directed to be listed for consideration under the heading admission on a date by.
There's a connected matter in WPC 3329 of 2025 between the same parties. It is already listed
We'll see that. On that day, make a
on
mention. We'll
31
have it.
it is listed. On 31st of March, it is already listed. The other matter.
Oh, so on 31st of March, along with
WBC 3329 of 2020.
So it's all right.
No, there's an interim order that.
Interim order shall continue in the meanwhile.
Published.
Interim order, if any, shall continue in the meanwhile.
Item 13.
Look, in terms of the last order of this honorable court, well, I have instructions stating that the committee so directed to be formed by the order dated judgment and order dated.
Just a minute, just a minute. What is, first the directions of the court?
Well, look, the order dated 5/2/25, my lord, passed by this honorable court in PIL 17 of 21.
Where is the direction? Which paragraph?
Your Lordship, the direction is at page 22 of my contempt petition, para 11.
Read the paragraph.
In such circumstances, we dispose of the writ petition with the direction to the Chief Secretary to the Government of Assam to constitute a three-member committee to be headed by an officer not below the rank of Additional Chief Secretary to the Government of Assam to examine the aspects regarding the violation of the master plan as well as with the environmental issues, if any, that is likely to arise with the establishment of the amusement park and construction of hotel and tourist complex over the land, which is being leased out to the respondent number 9 by municipal board. The said three-member committee shall conclude the exercise within a period of 8 weeks from the date of receipt of the certified copy of this order and submit its reports after providing proper opportunity of hearing to the parties to the writ petition and shall communicate the decision to them immediately after conclusion of the proceeding, subject to the
And
outcome
this
of.
contempt application has been filed by respondent number 9.
Yes, Your Lordship.
So
Now,
then that
thereafter, we have submitted the.
you are stoking the hornet's nest.
Yes.
They will next day decide, hold a committee and decide that yes, it does, and then you go out of picture totally. Who advises you to do all this?
Your Lordship, there.
Who advises you to do all this?
Because I was the bidder, Your Lordship.
Haven't you followed what we are saying?
Yes, Your Lordship.
You were the bidder.
Yes,
That
Your-
was questioned because it would have been a violation of the master plan and all that. And therefore the committee was to decide. And now you're seeking contempt against the officers, against the government. They'll say, yes, master plan has been violated. Let us revisit it.
I'm helpless, Your
Are
Lordship.
you still desirous of pressing this contempt petition?
Your Lordship, what has happened? Let me just point it out.
Anyway, but what have you done?
They have formed the committee, Your Lordship, and they have called me for the hearing on 26th.
Then this it stands discharged. Take down. Pursuant to unnecessary petitions,
That is the instruction I have, my lord.
Your Lordship, I was.
the learned counsel for the petition, SLECO. A PIL had been filed by the residents of Silchar town, raising a grievance regarding the decision taken by the erstwhile municipal board, bracket now Silchar Municipal Corporation, to lease out a portion of the Gandhi Bagh Park area of Silchar town to the applicant to develop an amusement park and to construct hotel as well as the commercial complex. Stop. After hearing the grievance of the petitioners, a bench of this court had directed, a division bench of this court, by judgment dated 5/2/2025, had directed that the Chief Secretary of the Government of Assam shall constitute a three-member committee, to be headed by an officer not below the rank of Additional Chief Secretary to the Government of Assam, to examine the aspects regarding violation of the master plan, as well as environmental issues, if any, that is likely to arise with the establishment of the amusement park and construction of hotel and tourist complex over the land, which was sought to be leased out to the applicant, bracket where he was respondent number 9 in the PIL by the municipal board. The said three-member committee, the bench had directed, would conclude the exercise within a period of 8 weeks from the date of receipt of a certified copy of the judgment and shall submit its report after providing an opportunity of hearing to the parties to the writ petition, and shall also communicate its decision to them immediately after conclusion of the proceedings. When this time schedule was not adhered to in constitution of the special committee of a three-member committee, the applicant bracket respond number 9 in the PIL preferred this petition seeking to initiate contempt proceeding against the answering respondents. So today, the Land Council for the petitioner submits that pursuant to the directions referred to above, a committee has already been constituted, though after the time schedule fixed by the court, and the applicant also has been summoned, has been called to participate in the deliberations. So, this court therefore is of the view that no issue arises for initiating contempt against the respondents, and in fact the contempt stands discharged.
Deeply obliged.
Application is dismissed. Follow the next. Yes.
The contempt application against the judgment and order dated 25/11 passed by this
Take us to the order.
operative person is at page 43, my lord. There are 32.
हम लोग लिखा है.
Proper remedy, therefore, in our opinion, is a fresh, unfettered reconsideration by the.
One second. Let us remind ourselves what has happened. Oh, that police officer. What did I say in that?
My lord, have directed the SLSCC to reconsider the issue as regards the status of the petition.
Now take us, now that we remember the background fact, tell us where is the direction?
Direction is at page 44, my lord. We thus set aside the impugned judgment and remand the matter to the SLSCC to reconsider the issue in a holistic.
Just a minute, they read paragraph 32.
Sorry. The proper remedy, therefore, in our opinion, is a fresh, unfettered reconsideration by the SLSCC on all relevant factors consistent with the Kumari Madhuri Patil, Ramesh Bhai Dayabhai Naika, and Ayub Khan Nur Khan Pathan, and Navneet Kaur. We thus set aside the impugned judgment and remand the matter to the SLSCC to reconsider the issue in a holistic yet calibrated manner without being guided or prejudiced by the.
Now, which have we given any time without?
Yes, 60 days was given from the date of.
60 days. Now 60 days have passed.
Yes, ma'am.
Nothing has been done.
Nothing has been done.
You have not been summoned to answer.
Yes, ma'am.
You have not been.
No.
Again, let notice be issued. Two, who would be the answering respondent?
The chairman of the scrutiny committee. Page 3. ये कौन फेंक कहते प्यार वो रेस्पोंडेंट नंबर कौन सी हाँ she was the Divyana. The applicant was a respondent number 2 in that petition. 2 and 3, because at that time she was
Then
minor.
This applicant,
There are 2 applicants.
applicant was minor, but now the applicant is a major.
Yes.
Take it. This application has been brought forth by respondent number 2 in writ appeal number 5 of 2025, which was preferred by the so-called perpetrator, the so-called perpetrator of the sexual offense, so-called perpetrator of an offense, of the offense of sexual demeanor against her, questioning the scheduled tribe status of the applicant, bracket respond number 2. This court had disposed of the appeal, holding that the issue in question was required to be reconsidered by the state level caste scrutiny committee on all relevant factors consistent with the judgments of the Supreme Court in Kumari Madhuri Patil, आपकी citations ले लेना, रमेश भाई, दा भाई, नाइका, and so and so Ayub Khan, Noor Khan Pathan, and Navneet Kaur, Harbhajan Singh Kundal, so and so. The SLSC was directed to decide the issue within a period of 60 days, to be counted from the date of receipt of the production of a certified copy of the judgment before the SLSC by any one of the parties. It appears that even though the SLCSC has been made known about this judgment, nothing has been done in that regard. Let notice, hence the present application seeking initiation of contempt against the respondent. Against the sole respondent, bracket SLCSC. Let notice be issued to so and so on steps being taken by the applicant within a period of 2 weeks, both modes returnable. In the meantime, they will decide returnable on your date after 6 weeks. In the meantime, they shall decide.
22nd April. Item 15.
Then 6. First time. First time.
Lordship, we had filed an IA previous to that, prior to this occasion, Your Lordship. However, there were some material defects in the IA. Your Lordship had instructed us to file a fresh IA for a condemnation of delay. We have done so, Your Lordship.
We had dismissed your application.
Lordship, with liberty to file it.
So you have filed a fresh application.
You file it.
You appear for whom?
Yeah, Lordship, the department, Lordship. Respond. The NML has been very departed.
What is the ground taken?
Lordship, we have taken the ground, and while passing the order, the single judge had not considered certain facts. Facts as such, that Lordship.
And we are talking about the
IA, Your Lordship. Lordship, what had happened when the matter was ongoing before this honorable single judge?
Where have you stated the reason for the delay?
Lordship, the reason for the delay is in page number, para number, Lordship 11, page number 6, Your Lordship. The mother of the petitioner was suffering from severe liver issues as well as heart issues, Your Lordship. While passing of the judgment, he had passed away.
They are condoning the delay. Let you argue on merits.
Much of it.
Delay condoned.
24th April. Item 16.
Lords,
Notice.
yes, Lordship. 3-0.
Both these applications are
Lordship.
application perfunctory.
I learned something, Lordship. I learned.
8 April. Item 17.
My lord, there is delay of 51 days, my lord.
Mr. Goswami, delay condoned.
Deep lord.
Less than 100 days, we don't apply.
Below 100 days.
24th April. Item 18.
You take all orders now.
Delay of 42 days, Lordship.
42 days.
42 days.
Notice 2 weeks, both notes.
Got it. 19 is also same.
19
Yes, same out.
on 8/4, 8 April. Item 20.
Leave to file appeal against the document. No, but why leave petition? That's not the practice. That's not the. Why leave?
My lord, petitioner was not a party in this writ petition, my lord. WPC number 256 of the party, my lord.
DB2 or DB3. Let this matter be placed before DB3. And DB3 for consideration. Preferably on, give a date on Friday. Okay.
Item 21.
Leave and go to return. Again, leave.
Right, please, sir. Well, this IA is for seeking leave to file.
I don't think that you require leave. Sahababu Khinji 1962, it's still fresh in our minds. Right, Mr. Decker? No leave is required. Anyway, we grant you leave. Leave granted, the appeal to be, have you filed your appeal?
Yes, appeal is there and
There is a delay also, I think.
there is a delay.
There is a
Please,
delay.
that may be condoned only. Only 38 days.
Leave granted, the delay so and so for the appeal to be processed. And be listed
Some urgency.
preferably on next week.
Obligation.
6 March. For admission, item 22.
Yes. Yes.
May it please your lordship. Your lordship, I'm appearing on behalf of my senior, Mr. A. Narzari. Your lordship, he had come, but suddenly he got stomach ailment, so he had to leave. Kindly, on my senior's request, maybe
But would you have any problem if we issue notice here?
lordship.
We'll issue notice here.
Lordship, kindly let my senior appear.
No, but your senior would also only pray for notice.
Okay.
You
Okay,
understand the language of your colleague, but you don't understand the language of the court. Later. This writ petition has been filed by a Bodo tribal farmer residing in Gandabil village in Chirang district, which falls under Bodoland Territorial Council area. In this writ petition, a challenge has been made to the two recent government notifications that gives a special land protection rights to persons of Nepali origin who are referred to as Gorkhas inside the tribal belts and blocks of BTC districts of Kokrajhar, Chirang, Baksa and Udalgiri. Another notification by the Assam government in its Revenue and Disaster Management Department was issued on 20th of July 2021, declaring Gorkhas bracket who are Indian citizens. Gorkhas who are Indian bracketing, who are Indian citizens and living in the aforenoted 4 districts of BTC before 10th of February 2003 would fall in the protected class under section 160 bracket 2 of the Assam Land and Revenue Regulation 1886. So this notification permits them, this notification allows them to get land settlement and protection in tribal areas. the Assam, anyway, stop. On 4th of January 2025, BTC has issued another notification accepting Gorkha certificates for the purposes of land allotment and settlement inside BTC areas. The contention of the petitioner is that these notifications are illegal, unconstitutional, illegal and unconstitutional. The contention is buttressed by the reasoning that the 6th schedule of the Constitution and the Bodoland Accord of 2003 aimed at protecting the land rights of scheduled tribes, primarily Bodos, in the 4 districts referred to above. The non-tribals were to have only very limited safeguards under clause 4.3 of the accord. These non-tribals could not have been given the same protected class status as the tribals / Bodos. It was also urged that Gorkhas are not scheduled tribe in Assam, semicolon, rather they are a migrant community from Nepal. It was also urged that Chapter 10 of the Assam Land and Revenue Regulation 1886 protects only backward classes who are primitive, lack education, and cannot look after their own land welfare. Gorkhas do not fall in that category today. The petitioner labels such notifications to be nothing more than vote bank politics, which would have a cascading effect on the tribal lands, the demography of BTC. For these grounds, it has been urged that it is the notifications are in teeth of the provisions contained in Articles 244 bracket 2, 275(1) of the Constitution of India. The 6th schedule, 275(1), 6th schedule, and Article 300A, capital A of the Constitution of India. Let the notice is issued to all Assam government provision. Notice to respond number 1 is accepted by MS Sumitra Sharma. Notice to respondents numbers 2 to give your name. Notice to response number 2 and 3 is accepted by so and so. Who are you appearing for?
Alco 4, 5, 7, and 8.
Notice to response number 4 to 8 is accepted by so and so.
6, not 6. 4, 5, 7, and 8.
4, 5, 7, and 8. I think you accept it for
9 to 14, 1 and 9 to 14.
you are appearing for 1 and 9.
Into 14.
You appear 1, 6, 9 to 14. I mean, yeah, 1, 9 to 14.
WPTPC.
Just to stand and say, just say notice is accepted so and so. Let counter affidavits let counter affidavits be filed by the respondents by the next date. The counsel for the petitioner shall afford copies of the petition to all the learned counsel for the respondents.
24th April.
Tell your senior that you argued and notice was issued.
I'm here, your lordship.
What?
I'm not well, your lordship, that's why.
It's all right. So we are doing something else. We are encouraging your junior. She was wanting adjournment. We have issued notice.
I apply to.
Please see that you pay her the fee for today. She has argued, pay her the fee.
24th April. Item 23 to 25.
Twenty-three and 24, Lordship. Lordship, on the last occasion, Lordship asked to provide instruction what happened to the or what order has been passed in WPC 808425 pending in before the Delhi High Court, Lordship. Matter was on 17 took, but on that day some time was granted to the registrar principal AFD, Lordship.
To see, not that Delhi High Court would have any persuasive value more than what parties argue here.
Lordship.
Nonetheless, we'll like to see the reasoning. I think there is only one thing going against you.
Lordship. That whether
the agreement which says that the emolument fixed at the time of agreement would not be reduced till the tenure.
Lordship.
But then it is a matter of common knowledge that if it's a post-retiral engagement with the government, the same department, then it has to be subject to what the person gets as pension. Right. But then your agreement doesn't talk like that. Mr. Tabildar will argue only that.
Lordship.
Okay. So let's see what is, we grant some time to you, about 4 weeks. Okay. At the instance of Ms. Sharma. At the instance of MSB Sharma London Central Government Council, the matter is adjourned to 3 weeks.
Apply.
Otherwise, also, Lordship, the Delhi High Court judgment is not connected. That is different.
Let's see. We have not yet decided.
Yes, Lordship.
To my mind, it should be subject to what pension you get.
Yeah.
Now, that is sub silentio. That's missing in that agreement.
But Honorable Single Judge has put on query that why are you still till today you are just discriminating these two persons only.
So that way we will not allow it to happen.
But
There is no stay. You're getting the money.
No,
he
I
had
have been
already retired.
retired. We've been
Retired.
Oh, you have already retired.
Yes, both.
So there
One is working, Lordship.
what money will you get?
Now, Lordship, I have been reduced in the person that
Sometime.
Anyway, all right.
Apply.
27 April.
Obliged, Lordship.
Item 25.
May I please, Lordship? Lordship, this is covered, my lords. Lordship has delivered on judgment. These are advertised posts, my lords. I have annexed it in my petition also. These are from Gwalpara. May I hand over, my lords?
Yes. We'll issue notice.
My lord, this is covered, my lord.
You'll have to respond to it. No?
Oh, then, my lords. Covered.
Don't throw your exuberance in a non-professional style.
My lord.
Give that judgment.
My lord. My lord was issuing notice, so I must stop.
Don't behave unprofessionally, no?
My lord, I'm so sorry.
The other side has to be noticed for whatever.
These petitioners are from Gwalpara, my lord.
Let notice be issued to so and so on steps being taken by the. You are accepting the notice
Lordship.
for all of them.
Yes, for health department, Lordship.
Mr. So and so accepts notice for respond number so and so. Please go.
Lordship.
Accepts notice.
Lordship.
If you want to file anything, you
Yes,
file.
Lordship.
Otherwise, it's a covered matter.
Lordship.
Okay. The land council, the land so and so, land advocate, or so and so submits that he shall be filing the counter affidavit in the matter by just a minute, by 16th of March. And let this matter come up for consideration on 20th of March.
Obliged, my lord.
Did you expect me to?
Item 26.
May it please your lordship.
Yes.
Page 46. I was appointed for 5 years as per the rules. Appointment order and the rule says if you are removed prior to 5 years, reasons has to be there. Only the replacement order comes, no reasons. Now affidavit filed said there was a committee held for inquiry, but before the inquiry
Mr.
was.
Roy Chaudhary, are you pressing Mohinder Singh Gill here?
My lord, Gordhan's case. Gordhan was taken care of by Mohinder Singh Gill. At 52.
That's right, but then you know the reason.
Well, the reasons has been furnished in an affidavit and no opportunity. Reasons were never given to me.
Do you deny this fact that you
But I
are-
have resigned from the second college. I applied for resignation in the second college. And this, I was appointed by the government itself. Our government has appointed me. It was not my own choice.
We are not inclined for the reason that you held that post for 2 colleges. You should have said that
Well,
no, I can't handle.
Because the government has allowed me. Government has allowed
Tell
me
me,
to.
is there any bar that you cannot?
Not as in the law, I don't find because it is regularly proceeding in every way. In many of the teachers have been given because to be a president in 2 colleges.
No, there's no right, only for the reason that it was not during that period. But those 5 years would have passed by.
My lord.
Now.
No, my lord. Up to August, I am there.
Up
to August, I am there.
August.
But only unceremoniously, only.
Unceremoniously, now they will come out with an affidavit that there is an allegation of.
My lord, that allegation also I could have refuted by saying.
I don't think you should.
Because I have given my resignation. And my lord, that if the reasons are not there, I was relying on that 2012 8 SCC para 44, though it dealt with order 41 rule 27, but in para 44 it has specifically said reasons had to be furnished to the person because reasons could have said no reasons were furnished in the impugn order, and the impugn order, my lord, only says that I have been replaced unceremoniously before 5 years. Even the affidavit, they say the inquiry was not completed. But in the inquiry, the affidavit that I have annexed, your lordship will find. What? In para 8 of page 62, the government affidavit says, however, the inquiry committee was not able to submit their final inquiry report because of the fact that the petition has been replaced by the said post of president. And my lord, I could not say before that the London single judge, before the division bench here, similar order was there of a London single judge, where also the minister behind the back has passed an order that you have been replaced. That was also upheld by the London single judge, saying that behind the back a minister cannot say when the government has allowed me to hold 2 posts. And I have given my resignation now. That was a London single judge order in Maneshwar Burman under this same malad. In para 17, malad. Para 17 middle, it appears that the input action has been taken under the dictation of a said minister concerned and absolutely behind the back of the petitioner without affording him a reasonable opportunity of hearing. It is also noticed that notwithstanding all these allegations, the impugn order did fail to spell out any such circumstance prompting the authority to nominate the vice president. Then, my lord, within this 5 years, the rules also says, my lord, I will place the rules before your lordship, my lord. I am giving the rules, my lord. It says 5 years with reasons to be recorded. Rule, my lord, 3, 4, subclause 4. 3, subclause 4. Quote it in the judgment. Quote it in the judgment.
Okay.
2012, 8 SCC, page 14.
P. P3. Reasons to be recorded in writing. No. Where is the paragraph? नहीं, कहाँ पर? Reasoning दिया है.
Para 15 of the judgment. Para 15.
Read that.
It is in the considered view of this court, so long as there are reasons recorded in writing requiring the replacement of an incumbent on the post of the president of a governing body of a non-government college, the order giving effect to such replacement would not require interference of court merely at the drop of the hat.
No, that's all right. At the drop of the hat, it can be done. But then there are reasons recorded in the writing. You say there are no reasons.
No reasons in the impugned order. No reasons in the impugned order.
It could be there. No. What is the impugned order?
My lord, the impugned order is that page.
Impugned order here is still.
My lord, my appointment, page 37.
No, removal.
Removal is at page 41.
Yeah. Page 41.
My lord, 41.
This order है. कहाँ पर? नहीं, एक मिनट 41 में कहाँ लिखा है? It says power conferred. The governing body in respect to the marketing college instituted is hereby constituted by the accounting. And which is the provision which tells, which
My lord, I have given
provides
that.
the procedure for meeting of the governing body and constitution of the governing body? Where is that?
The governing, my lord, I have given that rule, my lord. 3 subclause 4. I have given the rule, my lord. Another, my lord, I have one.
Subclause 4.
4. My lord, I'm giving the second copy, my lord.
No, constitutional procedure. The
My lord,
president
I'm giving, my lord.
Constitution of the governing body. Constitution of the government shall be governed by the governing governing college. Composition of the governing body, but constitution तो है ना, but who will constitute, how will? Who तो appointed the
Even my appointment order also says 5 years to be, reasons to be recorded before 5 years. My appointment order also speaks as such, my lord. Page 37.
No, we are looking at it from a different angle. Just a minute. ये तो entire governing body has been written. Where is that direction that the governing body can be reconstituted only after notice of 7 days, and the erstwhile the president only will fix a date? Where is that?
My lord, only that.
Now, why do we take annexure 4 as your removal?
Removal, my lord.
That's the question which you must answer.
My lord.
Why should we take annexure 4 at page 41 to be your removal?
My lord.
Which has been challenged by you, and your challenge has failed.
My lord.
We don't take it as your removal. We only take it as a constitution of the reconstitution of the governing body.
My lord.
Now thereafter,
Other members remain the same. Other members remain the same.
Oh,
Fine.
that's fine.
My lord.
My lord is asking where is the provision of reconstitution, the provision of reconstitution of the property.
My lord, your lordship,
And in what are the circumstances, and what is the notice is given.
4, my lord, your lordship may look
Order
into
is somewhere.
the tenure of the governing body will say that.
And this is speaking order at page 44. This has come when?
Page 44. This is, my lord, about, I complained about somebody
Order
here.
about the principle. That is irrelevant. No, that
Irrelevant.
you're alleging bias
My lord,
against that principle.
my lord, my lord.
Whom you complain. But that bias, it's neither here nor there. Now, where is that reasoning? Jahan par hai?
Reasoning only, my lord,
Just a minute, page 74.
minister's right to the director.
This is by minister.
Minister,
Who is he?
my lord. During that time, who was there? I don't know.
Government is not minister. The president of the government body shall be known. Who shall appoint him?
My lord, may look into section 4, tenure of the governing body. Before that, it has to be suspended then only. 4, tenure of the governing body.
No. They are only trying to find out justification for his removal. Mismanagement or mechanic. Minister is working at the dictate for the principal. And respond number 4 has been appointed as the president.
My,
Who appears for respond number 4?
my friend, my friend. You are,
I'm for the respondent, but take college.
You are appearing for?
I'm for the higher education.
Who appears for respond number 4?
His presence is
We have some difficulty in accepting this decision of the director.
No.
Now, he instead of suspending the entire governing body, he changes the president only,
No.
allows the other committees to remain.
No.
Now, this is by virtue of a reconstitution order. Now, reconstitution also he has to give reasons.
No.
Tenure of the governing body otherwise would be for 5 years.
No.
Now, he could have taken in the event of, he could have taken over or done something in the event of mismanagement.
No.
That required reasons. No reasons are being given. And minister is not the government, no.
no.
Minister is not the government. Now, why don't we take it that the minister was acting at the behest of the principal, Mr. Kalita?
That's it. Is number 54 of the.
Respond number 4 has nothing to do in the matter. He has been appointed. But then before we
Yes, sir.
embark upon the journey of finding out what was the reason, why do we will not lift the veil. Mr. Roy Chaudhary may not be running the college, though he claims to be an academic, but doesn't look like. He has resigned from there. What interest should he have in Barkhetri College?
My lord, very honestly speaking, if the impugn order goes by, I will also give up my place. Only thing, my unceremoniously, that is prestigious issue. I don't want to be a president anymore. But this unceremoniously approach,
No, हम लोग का लेट take that.
No, may I have notice?
can I make a small prayer, my lord? Because my poverty is up to August.
No prayer beyond this.
My lord, I understand, my lord.
We were all this while we were trying to find out how to keep you out of consideration. But then the reasoning has to be given. We can't hide behind anything. That's the only thing. Otherwise, you don't require your tenure ended. Otherwise, it would have ended otherwise in August. And you are an academician. You find out some other place. This is not your main vocation. That you feel hurt, you feel slighted, you feel disturbed because of the unceremonious exit. Nothing. Minister does not want you, but the minister is not the government. That we can always say. Unless it has to come to the director has to take a decision.
Only thing, my lord, something prior to August can be, if it is, can be disposed of. Could you returnable on the returnable date?
No returnable. It will long read. The appellants has questioned the judgment of the learned single judge in WPC number so and so dated 29/1/2026, whereby his removal from the post of president of the governing body of a non-government college, namely Barkhetri College, has not been interfered with, notwithstanding the fact that such termination of the tenure was before 5 years, which is the normal tenure, and without ascribing any reason whatsoever. The appellant was appointed as the president of the governing body of the college on August 26, 2021. According to the Assam non-government college management rules, now called Assam Provincialized Colleges and Assam Non-Government College Management Rules of 2001, every college affiliated to any central or state university of Assam and duly concurred by the state government would be governed by a governing body. Section 3 of the rules referred to above indicates as to what would be the composition of the governing body. First up, the president of the governing body would be an eminent person from the field of education who shall be appointed by the Director of Higher Education and shall have a term of 5 years. He may be allowed to continue beyond the period till his successor is appointed. The director also has the power to remove him before 5 years, but only for the reasons, only after recording the reasons in writing. The tenure of the governing body shall be a permanent authority, which is prescribed in clause 4, in rule 4, in rule 4 of the rules of 2001. The members of the governing body would have tenures as provided under the rules. And in case of the president, 5 years normally. This would, however, not affect the permanent nature of the said body. stuff. However, if the director is satisfied at any point of time that a particular governing body is not functioning in the best public interest, the director would have the powers to suspend the governing body and appoint an administrator who shall exercise the powers of the governing body during that period. But for that also, the director is required under the rules to record his views with reasons thereof through a speaking order for the purpose. The learned Mr. Roy Chaudhary, senior, Mr. Roy Chaudhary, learned advocate for the appellant, has drawn the attention of this court to the order dated. What is the date of this order at page 41?
Date is, my lord, here, 1/7/25, digitally signed below my right hand side. 1/7/25, digitally signed by such and such.
क्या लिखा है कौन? One 2025 issued under the signature of the director of Higher Education Assam, reconstituting the governing body of the college in question, with respondent number 4 as the president, and the other members and the other erstwhile members remaining on the panel of the governing body. Stop. It has been submitted that no reasons have been accorded for removal of the president, that is him. Stop. Even for reconstituting the governing body, reasons had to be recorded, especially of mismanagement. And then, in that case, an administrator was required to be appointed to look after the affairs of the governing body. The governing body as such, as described under the rules of 2001, would be a permanent body with the tenure of the members as designated, as a tenure of the members as stated under the rules. It is the contention of the appellant that since he had raised complaints against the then principal of the college regarding financial and administrative irregularities, based on which an inquiry was conducted and 2 increments with cumulative effect was withheld, and 2 increments of the concerned principal of the concerned then principal was withheld with cumulative effect, he has been targeted. The learned counsel for the Mr. Roy Chaudhary, learned counsel for the appellant, has also contended that the learned single judge did not appropriately appreciate that the reasoning given by the director, reasoning given by the higher education department behind such decision was the appellant having held 2 presidencies simultaneously. It is submitted that there is no proscription. Rather, there are several examples of one person holding 2 presidencies of the governing bodies of 2 different colleges simultaneously. But that apart, it has been submitted that apparently it appears that it was only on the asking of the minister of the higher education that aforementioned decision was taken. It is thus submitted that minister is not government and the director had to take an independent decision in that regard, which had to be informed with reasons. The reasons for an order of ouster of the appellant cannot be inferred or be supplied subsequently. Or be supplied, or else, it is argued, the order of termination is bad. Respondents number so and so are being represented by so and so. Let notice also be issued to respond number 4, both modes, thus the returnable 3 weeks. In the meantime, the learned counsel appearing for respond number so and so may respond to the petition, may respond to this memo.
All right.
8 April.
Immediately. We'll come back in 5 minutes. ये था what?
Item 27.
I want to say, Lordship, PW is the main party.
Yes.
PWD is the main party, Lordship. Their name not shown in the cause list, Lordship.
I can't hear you.
PWD is the main party in this case, Lordship. Their name not shown in the cause list, Lordship. So some other day, Lordship, matter may be adjourned to that.
Then we should note it.
I think 27.
The appellant has questioned the judgment dated 28/8/2025, passed by a learned single judge in case in WPC number 5026 of 2020, rejecting her claim of being paid pension, treating the service of her ex-husband as having been regularized. The husband of the appellant / late Bidang Basumatari died in service after serving for nearly 20 years on 26th of February 2018. The contention of the appellant is that her husband had received the regular scale of pay under the ROP rules, got annual increments, as also enhanced grade pay after completing 12 years. All these facts stood recorded in the official service roll maintained by the department. However, the executive engineer Public Works Department, though admitted the long service of the husband of the appellant on a sanctioned post as a Tone, the executive engineer, respond number 4, admitted the long service of the husband of the appellant on a sanctioned post and forwarded a fresh proposal to proper channel for posthumous regularization of the workman's service so that the family pension could be granted to the appellant. However, the same was refused on the plea that the service of the employee was never formally regularized during his lifetime. the learned single judge, relying on Ujjwala Najari ka Ujjwala Najari ka citation. Yeah. क्या लिखा है पढ़ो? On the decision of a division bench of this court in Ujjwala Narzari versus State of Assam and others, citation there, and State of Assam versus Upen Das and others, दोनों की citation ले लो, did not interfere with the decision of the authorities in not posthumously regularizing the services of the workman. Now, the learned single judge has also prima facie held that a work charge establishment differs from a regular establishment and therefore any contention regarding similarity in the service of the deceased employee as work charged employee with that of regular employee was not legally valid. Let notice be issued to the respondents. Notice to respond number 1. Notice to respond number 1 and 2 is accepted by MSR Bora, learned junior government, learned junior government advocate. Notice to response number 3 also you can accept.
Lordship. Well, I'm only for 2, Lordship.
You're only for 2.
Yes, Lordship.
No, but therefore 1 also. Don't make that distinction. 1 also you are capable.
Yes.
Notice to response number 1 and 2 is accepted by MSRP Bora. Notice to response number 3 to 5. 3 to 5.
4 and 5 BTC.
No, 3 to 5 is accepted by, I think,
Any by PWDs can be counted out by the PTC.
4 and 5 by BTC. 4 and 5 BTC.
4 and 5 is BTC, 3 is by?
Standing council PW.
And 3 is accepted by, just inform the standing council. 3 is accepted by the standing council, Public Works Department. And response number 4 and 5, and notice to respond number 4, 5 is accepted by. We are not inclined to put the appellant to the task of, spending money for filing requisites. Therefore, she's a widow, she's not even getting pension. And 4 and 5?
SCBTC.
Standing council BTC.
6 is finance.
6.
SC
Standing council. And 7?
Accountant. SC accountant.
I
Mr. Just inform.
No.
We are saying that they have accepted.
No.
And Mr. Talukdar and so and so.
No.
By, on behalf of respondent number 7, counter affidavit. On behalf extra copies and respondent and their names shall be reflected in the cause list. Counter affidavit to be filed by the next date, re-notify after 6 weeks. Inform everybody.
Lordship. Lord.
30th April 0. Item 29.
Yes, Mr. Das.
29 and 30.
29 and 38, 30. 30, item number 29 is writ appeal 400, which is admitted, and item number 30, 401, it is only notice has not been issued in this case, man.
No, but what is there now? I don't think you have any case left to be argued.
My
You don't
lord,
have any case
my
left to
lord,
be argued today.
let me put it, my lord. I have a tough time. I'll have a tough time to argue before this court.
No, but-
I know. There are 2 points, which is I just felt.
Merits. You'll not have a tough
no,
time on merits.
I-
You have a tough time so as to tell the court that this appeal is required to be decided to.
No, that's what I'm saying. No, that's what I'm saying, my lord. My lord, only one point, my lord, will kindly look into, which I felt that this is an e-auction process. It's a mining contract for a period of 7 years. One is a technical bid and one financial bid.
All right.
Technically, you have to qualify, then only financial bid. In this case, my lord, this is 10 bidders, my lord, participated. Out of 10 bidders, my lord, 7 bidders were disqualified. Now, thereafter, financial bid.
No.
Now, the whole system.
Mr. Das, we are interrupting you. Sorry.
Yes, I so.
We are interrupting you, but for the reason that you look at this. This advertisement was issued, tender was floated when?
No, it is right. Tender,
I'm talking
I know.
I'm talking about that point
No,
of
that's
time.
your lordship is what? Definitely, my lord. But today we are in 2026.
So otherwise also
This is high.
lost.
My lord, what I am saying, the process has started and live auction also has done. 2 particular bidders. My LOI received to me. LOI was issued to me.
Therefore, the other bidders also, whoever has been selected in the later process, something has been done. No? But the entire process, they have asked, the court, single judge has asked for a fresh tender.
My lord, what
With
is
another 7 years left.
My lord, this,
6
no,
weeks have
that's
passed.
what I know that's a part where your lordship will ask. That's what the only point I have to satisfy
We will
today.
see on the reasoning given by the learned single judge. I mean, the reasoning given is debatable. But the days at which we have been called upon to decide this appeal precludes us from exercising our powers. For the
Only,
reason that 6 months or 7 months is left on that 7 period. 7 years.
my lord, that's right. That's
Take a
right.
call, ask your client if he wishes to pursue it. We will be dismissing it in no time.
Right.
There is no
My lord.
difficulty. And we are making it, very, very obvious to you. It is not a question of prejudging. We have told you the reason. Period is less. So it would be a complete waste to go into that exercise of entering into an agreement, giving lease of mining to somebody for say a period of 1 year. That will prove to be very, very expensive on the annual of economies of scale. 1 year mining, what will you do?
No, that's true, my lord. What I was worried in this case, and what the learned single judge also found, the entire system of the e-auction process. My lord will kindly see e-auction process. There was no question of giving a hard copies and deciding it. This is what the learned single judge said.
No, learned single judge talks about many other things. Primacy of reason, primarily the reason is that when there was only one person left in the fray, they should have cancelled it and should have refloated it. That they have not done. They've done it thrice. And then Mr. Diganta Das was always the preferred one.
My lord, I will just give a reply. My lord, of course, I will talk with my client.
If you no, I'm not asking you to withdraw. You tell us, you argue, and we shall finish it with that.
Whatever your lordship has said, I'll have a word with my client. Because instead of getting a dismissal, if he says, no, I am not pressing it, I think that will be the better. But what I
reason?
No, but
leaving it open for you to participate. And of course, since you have suffered the bad weather for so long, still you were in the fray and you want to be in the fray. That would be taken as an example of your being
but the learned single judge, with a great respect to the learned single judge, I was not on a single bid, only single bidder. There was 2 bidder in the live auction. Two bidder in the live auction, my lord. So, 2 bidder.
We have followed 2 bidder.
Yes, 2 bidder, not a single bid.
But look at this. No, what do you have to say about this small window left? Small time left. Let it go. You participate in the fresh bidding. Take a call. Otherwise, we are not inclined.
I'll take a call.
At this stage, only for technicalities.
No, I do understand, my lord. That's what's troubling also. I thought that your lordship will first put a question to me, then what about the period? That's why I said, today we are in 2026.
Yes.
Today we are in 2026.
This tender would have been finalized. The period would end when? Would have ended when?
30? 27.
27. 1.5 years.
That's
This will be
how-
7 years, plan.
Let me.
And for mining, you have to submit so many plans.
No, that plan.
That will take another 6 months.
What has happened when the interim order was passed by the learned single judge, saying that no, what they will not proceed, but in the meantime, my mining plan, everything I'll prepare it.
Take a call, Mr. Diganta Das. Tell your client that it would not be beneficial for him, and otherwise the court is inclined to dismiss it straight away.
I will convey this message, my lord. Definitely, my lord, I'll convey it.
Let them proceed with the tender.
Yes. It will end in 2028.
Does it make a difference?
Whatever may be, my
Does
lord.
it make a difference?
I'll ask my client. We'll have a word with my client.
So out of 7 years, 5 years have gone by. Where will you get the time to have every geo coordinates, decided? And then so many questions, so many other litigations with respect to mining. Suppose you become successful in the tender, but otherwise somebody will say that this area is not there. It has been allotted to me. Look at this. Most of these mining leases, they run through this kind of litigation.
I know, but this is one part where I'll ask my client. But so far as one part is concerned, my lord, it is entirely on e-auction process. There is no question of a hard copy. All was decided.
Bringing this point,
yes.
Hard copy, that is not the issue on which the single judges.
No, what has happened?
Now, look, come to the judgment.
Yes.
Now come to paragraph 49.
49.
Internal page 30 of the judgment.
Yes, I have marked that also. 14. My lord, the court have given excess consideration to the above aspects of the opinion tender process need to be annulled for the following reasons.
And now reasons he says.
A perusal of the meeting.
First reason which he has
yes. Clearly, so if there is one technically valid tender, the tender process has to be annulled and cannot further proceed to the second e-auction stage. It is also seen that tender process in the instant case has not been earlier annulled on 2 consecutive occasions for the reason and resultancy the respondent were required to annul the tender process and start afresh, which was not done in spite of the fact that there was only one technically valid bidder.
This is which is weighing with us also.
As per
now, come to the action on the part of
respondent, forest official not to cancel a tender process.
It's a continuation. No?
Yes. Third, the court has duly taken note of the communication dated 27/7/2000 issued by so and so, which was also there were recommendation for cancellation earlier tender process, issuing a fresh by bringing the NIT document in line with the online e-auction system.
It's irrelevant. That's not the
now the court has duly taken note of the long e-auction notice dated so and so. That is stipulated the mining contract would be for period. It is on the basis the bidders have quoted the rates. In view of the various litigation, 2.5 years have already passed by us, and as such, in the opinion, because if on the basis of
it is only till 2027. How does he say 2028?
So and so, 7 years. So and so, it would lead to a loss of revenue where the bidder would have not even quoted for this period, would be entitled to undue value. That's what your lordship is saying. That today we are in 2000.
So you have an argument to the contrary.
Yes.
There is a Supreme Court judgment also, Subodh Singh Rathore.
Yes.
That there is some privity, there is some sanctity of the privity of contract, but that stage has not come.
Yes.
Correct. So otherwise, the rates which were offered by the bidders that time, now should we even interfere at this stage, ever even contemplate to, there will be many others who will come that after so many years, now we will upgrade our bid. Can't be done now. It should be annulled.
Yes. Let me get back to my client and I'll get back. Maybe get a call.
I thought you will do it today. Anyway,
Yes.
take telephonic instructions, come back to us. We have reasons both ways.
Yes.
Either we dismiss it as practically having become infractuous, or we record all your arguments and say for this reason we are dismissed. I couldn't have been
Yes.
more transparent.
No, definitely, man. That's the point which I also thought while looking into brief. That's your lordship will precise us. Today is 2026. How many years you will get it?
And where is the breach of any law or wrong interpretation of any law with respect to ground number one?
But that judgment is only your lordship is right when there is a privity of contract between the parties.
No, that's all right.
Yes.
The only ground which you can raise is that, well, it was not done, it was not annulled, it was again revalidated. So therefore, this question should not have been relegated to that stage when there was first person left in the fray. Anyway, we are not inclined because of the period of time, efflux of time.
Yes.
When do you want it?
Maybe a week, not much. This is, of course, I have to take instruction. Week? Monday? Monday will let this matter come on Monday.
We have heard Sri Diganta Das, learned senior advocate for the appellant in WA number 400 of 2024. And the other, you are appearing.
I'm sorry.
I'm for respondent.
Please.
And so for respondent of time.
I'm Mohan Kumar.
We have primarily considered the fact of on going through the impugned judgment. What has caught our attention is that if the tender process is finalized in any manner whatsoever, it would only be for a period from 2021 to 2027. And today, with the efflux of time, only with the efflux of time, less than 1 year would be left to stop. In that view of the matter, it would not be beneficial either for the state or for the parties, including the appellant, to question the judgment on other technical grounds, other legal and technical grounds, as the period left would be even lesser finally, which would make the mining lease absolutely unworkable. Mr. Das, on hearing the observation of this court, seeks some time to take instructions in the matter whether to prosecute this appeal or whether to prosecute this, re-notify on.
Just 1 second before closing the file. I just want to show page 79, kindly see, man.
Page?
Just troubling your lordship, page 79 or 400. This, if your lordship looks into page 78, kindly see, my lord, contract permit period, lordship got it. At page 78, see 4 is the question, is the matter Dikram Sen, 7 years from the date of signing the agreement. Lordship got it? 78. That is column number, this is 4. There are different malls. This is, if you see at 4, column number 1, 2, 3, 4. Column number 4. 7 years.
Dikram is the same area for which you had.
Yes.
But lordship kindly see
No, this, Mr. Das, this argument of yours would, if people are not, have not been doing this tender matter, then perhaps your argument would absolutely take the court by surprise. Now, this years from the date of signing the agreement talks about the operative portion of the leftover period. It doesn't talk about another 7 years. They can't say that tender is for 21 to 27 and therefore it is signed in 27, another 7 years. That would be revalidation of something. That is not the ground. It is for with respect to the fact that mining would begin only after that. And the period remains fixed 21 to 27. That reading of this clause would make it absolutely unworkable.
Yes. Deeply obliged.
Monday,
Monday.
2nd March.
Monday, 2nd March.
Item 33.
Item? Government. Yes. MS Verma, tell us.
Lordship, on the
The,
last.
the other bench took note of your objections.
Yes.
Now, what do you have to say, Mr. Khatniar?
Regarding medium of instruction, although there is no.
No, medium of instruction is something else. But please go through the order. The order dated 9/2/2026 passed by DB 3.
Yes, madam.
Now, what is this? Where is the statement that you have issued mandatory instructions to all unaided schools? That is what she is interested in presently. Correct, Mrs. Var?
Yes,
Yes,
Lordship.
that we have annexed in our earlier affidavit, madam.
You tell us, show us the date.
Yes, madam.
The court may want to look into the website for which the school education department shall provide a person conversant with the operation of such website to assist the learned standing counsel for the counsel is missing for the school education department to enable the court to navigate through the website.
Yes, ma'am. Those persons are available
Now,
today.
give us the affidavit which says who you have brought those persons.
Yes, ma'am. They are available, madam.
No, you ask her to be satisfied. We don't want to navigate.
Lordship, the affidavit and the notification which my friend is referring to, they had filed that affidavit on 18/6/25, Lordship. That is a different one. That is guidelines for registration of vernacular schools, Lordship. It has nothing to do with my PI. In fact,
You're right. You're right. Now, Mr. Khatniar, please don't conflate these two issues. We are not asking for the guidelines. Guidelines are very clear. That's for the schools to understand or not to understand and then seek clarification.
Yes.
Now, what was directed to you, the department, was that you must ensure mandatory, instructions that every unaided school shall register itself. Then only it'll be beneficial, no?
Yes, madam. For current academic year, my lord. For this academic year, my lord, we are contemplating to do it, my lord.
What will happen now in March?
Because admission will start from April, my lord.
Now, you have brought all those technical experts for us to navigate through the website. We are not interested.
Yes, ma'am.
We are interested in your bona fides. Now, there will be only 10 schools on the portal. What avail would it be of so far as taking the right to education to any logical conclusion?
In case, my lord,
you don't want to, impart education to people in need.
No, my lord.
Otherwise, you would have done that, no?
No, my lord. In fact, that was the prayer. There is a prayer made in the petition regarding the web portal, my lord.
Do one thing. We would be rising now. You please see the website along with me, and just find out whether there are more number of schools than what you had seen the website.
Lordship, can I take Lordship to page 51 of my PI, Lordship, for a second?
Page 51.
My friend is submitting now.
No, your friend was trying to deviate from the issue. That's all right. We have understood that.
Lordship,
So, but then now we are telling you, we are asking you to see that. See, these persons have come from the department to make you you please see and then say that if it is up to your satisfaction, we will again see that.
Lordship, what the notification which my friend is now going to refer to, if Lordship comes to page 54 of my PI, the other operative part which I want Lordship's attention is at paragraph 6, Lordship.
Page 54.
We had filed a PL prior to this regarding.
One
the-
second, let me come to page 54. Yes,
Page 54, paragraph 6, Lordship. It has been specifically pointed out that in the policy guidelines contained in the OM dated 2/9/21, in clause 3 of part B thereof, it has been provided that the State Education Department shall officially announce about the issuance of admission forms under 12(1)C under the Act of 2009 through websites, regional newspapers, reliable media, and that the admission forms can be received free of cost from the respective schools, and the filled in applications is required to be submitted to the respective schools along with requisite testimonials, and further that the respective schools will design the
no,
application
so
form
that
as
they
per.
will do. No, they don't, they have not fixed a cutoff date. That
Lordship,
by 1st of March.
what I'm trying to tell, Lordship, it is very clear in this order that it need not be a direction from the court every year that they have to issue notifications.
That's right.
Lordship, it is very clearly stated in this order that subsequently
I
after.
think you're also going on a different issue altogether. Now, what we are concerned with is the observation made by DB2
Yes, Lordship.
that
The recent
where is
one.
the instruction that all schools which are unaided, also whether vernacular, non-vernacular, they must come on board.
Yes,
Then only
Lordship.
the vacancy position would be known, no? So that is what I'm trying to know, whether it is for this year, for succeeding years, that'll happen. You start,
Lordship.
let there be a start now. If you want for eternity, situation would not improve.
In 23 also, it was said that
Forget
they will
about
do
past.
everything before the month of March starts. That is the activity calendar.
Forget about past. Now today in 2026, where is that notification? Where is that mandatory guideline issued by you, Mr. Khatniar?
Yes, my lord. For that, my lord, for this academic year, we are going to contemplate to issue
When?
within this month of February, my lord.
Before March.
Yes, my lord.
Before 1st of March.
Yes,
So
my lord.
February ends on 28th.
Yes, my lord.
We are keeping it now. We post this case for 10th of February. We must have that date.
10th of March.
10th of March.
Yes, my lord.
Lordship, it will be late. First week.
No. We will.
My lord, we
Only 8 days.
Yes,
my lord, we
Lordship.
fix it on the first week of March, my lord.
No, but then you will take out the vacancy position.
When will
We'll
the
issue the
schools
mandatory
register?
guide
The session starts when?
from April, my lord.
Session starts from April.
Yes, my lord.
Okay, then March. We are postponing it for March 10.
Yes, my lord.
MS Verma, please remind us on that date.
Lordship, 6th of March, Lordship, because we have a very short 14th.
6th of March, this bench may not be available. You wanted to go before that bench, I can give you.
Lordship.
The earlier observation of that bench is very, very effective. So I think let it be on 6th, it will be before DB2.
No, Lordship, you can fix it on 10th, Lordship. We'll leave it to. Because why I was
In the meantime,
suggesting
today,
maybe-
since the
Yes, madam.
technicians have come, you please
Check it up, Lordship.
check it. Show it to her.
Yes, yes,
Anyway, not necessarily in court, you can show it there.
Yes, my lord.
All right, you do one thing. You have a look at that. I think in the court also you can see, because the order is that it shall be displayed.
Presence of the court, Lordship.
You do it, no?
We'll do it, Lordship.
We would go by your certification today, unless controverted by Mr. Khatniar.
Yes,
So you look at it, and we will come back again at 2,
Yes.
and then we'll fix it.
Lordship.
इन लोगों को जो अवेलेबल कर दीजिएगा यहाँ. Something will be done. All those technicians.
Yes.
द्वारा कोई plan. Call them here. I'll tell them their presence must be acknowledged. Call both the ladies who have come. Now we are calling you only to tell you that you're not unwelcome to these proceedings. We acknowledge your presence, correct? But that stage has not come where we will require, but our IT team will help you. You can demonstrate it here before the advocate for the petition. All right, we come back again. Yes.
Very disappointing.
Very disappointing. What has happened?
25 for the session.
Louder, louder. Can't hear you.
For the session 25-26, out of 10,000 schools in Assam, Lordship, they could manage only 218 schools registered and 100 are repeated schools. That means there's just 108 odd schools registered with the department. They have segregated into secondary and primary. We are not on that. Our children will go from class 1 to 8, Lordship. And all schools are up to secondary these days. Whether they have a primary registration or not, whether they have a secondary registration, whether they are affiliated to CBSE or not, it is for the department to check. I can just place this small list I got from the department, Lordship. They have rejected the schools on the grounds that the medium of instruction is not vernacular. On these grounds, half of the schools have been rejected. And in the
Well, why, Mr. Katniar? What is the reason for this insistence on vernacular medium?
As per rule, my lord, it is not clear. There is no distinction regarding medium of instruction. But while developing the portal, my lord, a cabinet took a decision that for the first time they will allow only vernacular. The region was given in the.
What is this first time, second time?
Region was given my lord, to promote vernacular education and strengthen regional language instruction.
Vernacular, but this is education. You just don't want people to choose that school.
That was the decision taken by the cabinet, my lord.
Vernacular, I mean, vernacular medium doesn't mean you're giving fillip to vernacular growth of, I mean, development of vernacular language. That makes no sense to us.
Act doesn't provide.
Prima facie, it doesn't make sense to us. He says that there is a purpose. What purpose? How can you improve vernacular? And to tell you an example from civil society, you know, in vernacular would be Hindi also. Vernacular here, you would refer to Assamese. But, you know, most of the literatures in Hindi, they have been educated in English. And they have their special subjects as English literature. One such example is Harivansh Rabbit. He's a professor of English, right? Wrote in Hindi. But that, I don't think it's logical. You have not given a thought over it. We don't want to write this. If we want, we can also give our own opinion. Now, vernacular also, but that is also very disappointing. She has rightly said 200 schools.
Not even 200, Lordship, because their reputations in the school.
Tell me,
and very sadly, Lordship.
Tell me what list are you going to, what is your expectation of 2026-27?
They don't have it in their website even now. The drop down shows 25-26. When I asked what about 26-27, they said that they are yet to.
25-26 is over now.
It's over. Lordship, 25-26, only 2 children were admitted in Karimganj vernacular language. This is the state of affairs, Lordship. Anyone who's sitting and making these policies, Lordship, would like to ask them whether they are sending their children to vernacular schools.
What do you suggest? You just can't look at us like this.
Regarding vernacular, that was a decision.
Now, vernacular also. Where is the direction to register that mandatory requirement? Where have you issued that? Where has the Secretary higher
that was issued earlier. That was issued, my lord. But for this academic year, current academic year, we are contemplating to do it, my lord.
Seriously, Mr. Katniar. Then we issue a direction.
My lord, we issue direction, my lord. But for
But
26, 27,
will say that you have not taken any interest.
26,
You want that observation.
26, 27, my
Mr.
lord.
Katniar, you want that observation.
No, my lord. I'm
Then
not saying
why
that.
do you say that pass an order?
26, 27, my lord, we are contemplating to do it, my lord. And in fact, I have also suggested, my lord,
Assurance
because
you will do that. Within a week, you shall issue a direction.
Yes,
and you
my
shall ensure compliance of it within next week of 1 week. That's in the second week.
yes, my
And
lord.
in third week, you will come up with a list. That show some bona fide.
Yes, my lord.
We are not asking for any benefit to us.
Yes, I understand, my
Your
lord.
student.
Yes, my lord. That I understand, my lord.
And that's the policy of the government, central government, that you are under an obligation to do that.
This is welfare legislation, it has to be implemented, my lord. That I understand, my lord.
Taking any interest. Who would be there? Should I call Secretary of Education?
No, my lord.
But not for the purposes of penalizing him.
Yes, I understand, my lord. That I can convey, my lord.
You seem to be very reluctant in coming up with a proposal. You are telling us only what you have got in the affidavit. So we'll ask, then we'll say, we'll record that this is the mandate under the right to education. And this is what is happening. And this is the PIL. Therefore, we are passing an order. We'll have to say that you have not done your job.
No, we'll do it, my lord.
When?
My lord, give me a 10 days time.
Therefore, I'm saying that
Within
don't
10
take it
days, my
upon-
lord, we'll issue the instruction.
Therefore, we are saying, Mr. Katniar, don't take it on me. Let us call the secretary. And give it, and we'll do that. When do we get to see him? The secretary. It's very difficult. No, how do we close this petition? How do we ignore this? I know there is some difficulty because of the impending elections and all that, but question is that we can't give a short shrift to this kind of an argument in this petition. I am fully conscious that this is one of the agendas of the government. Agreed. But then this must receive the prime focus. If you want the state education to improve.
First week of March, my lord.
Who's the secretary?
Mr. Narayanpur, he is the commissioner and secretary, my lord, now.
What I do is this. Now you talk to the secretary. I mean, there is a tendency amongst officers to take this summoning as some kind of a punishment or something. We don't want to spread that message.
Yes.
But then you take the call, tell the secretary today
Yes, my lord.
that this was the view of the bench. And in that case, we will have him called. We are adjourning the matter for today. You take instruction, come back to us on Monday with a timeline.
Yes, my lord.
Come back to us on next Monday with the timeline. All right?
Yes, my lord.
This is the only indulgence that I can give you. Take that. We have heard Ms. Anita Verma, the petitioner in person, and Mr. Katniar, learned standing counsel, Department of School Education. So the online portal for implementation of section 12, bracket 1, bracket E of the Right of Children to Free and Compulsory Education Act 2009, bracket hereinafter referred to as RTE Act, has been made operational. But the fact remains that for this session 2026-27, there has the mandate to all unaided schools has not been issued to get the respective schools registered on the online portal. Pursuant to the order passed by this court on 9/2/2026, where the court took cognizance of where this court took cognizance of the fact that since the next admission session is likely to commence in the month of April 2026, it was obligatory on the part of the state to make all endeavors to ensure that the portal is made operation. That good number of schools register with such portal in order to assess whether the policy of the central government with regard to education is being properly implemented. This court had expressed a desire to look into the website and had also asked a person conversant with the operation of the said website to come to the court to assist Mr. Khataniar, who would have in turn made the bench, who would have in turn enabled the court to know whether A, reasonably good number of schools have registered on the portal, and the vacancies in such school for admission from class 1 to class 8. The website was the working of the web, the website was, what do I say? The website was viewed by Mr. Khataniar and MS Verma, learned petitioner in person, with the assistance of the officers from the department. But what was found out was only a dismal performance of the state in that regard. We don't want to write that somehow or the other. But what? क्या लिखा है? But what was found out was not very encouraging and satisfactory. There is no enlistment of schools for the 2026-2027 session, leaving the needy and desirous students to opt for such schools. That apart, what surprises us is the observation of MS Verma on viewing the portal that many of these schools which had applied to be registered on the website were rejected because the medium of instruction in such school was not in the vernacular. There is nothing under the act or the rules or the policy of the state to only register such schools which impart education in vernacular language. Mr. Khataniar Mr. Khataniar, beleaguered as he was in the court, submitted that perhaps this could be only for the purposes of giving impetus to vernacular language in at the level of teaching in schools. This reasoning does not appear to be convincing to us. We have requested Mr. Khatniar, Learned Study Council, to make a consultation to let the secretary of the department, let this commissioner come secretary of the department know that this approach cannot be called, and that's it. Consult with the commissioner come secretary of the department for making the policy under the RTE Act effective, and for that it would be necessary that a mandate is issued to all unaided schools to register the institutions on the website, on the portal, failing which, the education department will have to take necessary steps to command compliance. So any failure of the department in doing so would thus necessitate an interference by this court. The registration of schools would be the first step. Registration of good number of unaided schools would be a first step in realizing the goal under the Act and the policy framed therein, policy framed thereunder. Mr. Khatniar shall also inform this court on the next day as to the rationale for rejecting such schools to be enlisted or registered on the portal who do not impart, where education in vernacular is not imparted. This is one of the major objections of the petitioner, that for good education, such distinction ought not to be made, and it should be open for the desirous and needy students looking up to the state to have a choice of vernacular and non-vernacular schools for them to prosecute their studies. The next session begins from April.
Lordship, March. The admission
He says
process.
April.
No, Lordship, the admission process, their activity calendar at page
The next
43.
session, bracket 2026-27, begins in March.
Process starts in March. Admissions are from 1st April.
Begins in March.
Yes, Lord.
That's all right. Begins in March. Stop. Under such circumstances, we direct Mr. Khatniar to ensure that a command is issued to all unaided schools to register themselves, registers the respective institutions on the portal, and if possible, take a decision not to reject such schools where education is not imparted in vernacular language, vernacular medium karna har jagah jahan language. Mr. Khatniar to inform this court about the outcome of such consultation and to inform this court whether the needful has been done in time so that students are admitted for the coming session in schools.
Lordship, just a small addition to this, if Lordship finds it correct. Lordship, the schools also ought to put it on their website, their vacancy of 25%. It is there in their OM, Lordship.
No, that means only no, because that is under the policy, the register. That means they'll have to they just don't register like so and so high school, lower primary or upper primary, whichever. They have to say that this is the school we are registering it. 25% of vacancy is this.
Lordship,
register themselves along with the clear vacancy position in such school
on their own website.
For this policy, namely 25% of the 25% of the vacancy for a year. Which information has also to be which information is also required to be displayed by the schools on their own websites.
Yes, Lordship.
And the only thing, 12 only thing,
all schools do not have their own websites.
Most of the unaided schools, minority schools have their websites, Lordship.
Anyway, we'll see. Mr. Khatniar, don't just sleep over it.
Yes.
Don't just sleep over it. Next date, we will call the secretary.
Yes, Malad. I'll ensure it, Malad. But
today
only
you
thing
talk
is,
to him and say that what is to be done. At least tell us that this is the maximum that you can do under the act.
only request, Malad, in the order, Malad dictated that class 1 to 8, but in the section, Malad, is only class 1, Malad.
No.
Yes, Malad.
Who says so?
Yes, Malad.
Class
12-1C, 12-1C, Malad.
The petitioners would not
That
come
is
here
not
only
the
for
entry
taking
level
admission
here,
in class
Lordship.
one.
They have
1 to
made
6.
a difference on that.
For
In
entry
other
level
states-
class 1, Malad, I'm trying to say, Malad, for entry level class 1, Malad.
Lordship,
Once it's admitted in 1, Malad, up to class 8. For
Lordship,
entry
it
level,
is-
it's 1.
Therefore, you have to say which is if they are admitted in class 1, can they be admitted in class 4?
No, Malad. As per the mandate of the section, Malad, it's 1, Malad.
Class 1 to 6, you give an explanation to
Yes,
us.
Malad.
If vacancy is there, Lordship, the child can go even in class
Let's see
5 or 6.
what steps they wish to take for implementing this.
No, we have lot
Next
of
day, tell us the date.
proceedings.
10th of March.
March, Malad.
Lordship, by 2nd, he will inform the court about the consultation, as Lordship had just told him.
No, that was if we had
Lordship,
not
we
dictated the
can
order.
have one date before that, Lordship, because
Don't put that snooze around the neck of Mr. Khatniar. Let him do that. We have told him.
Yes,
Next time, you're not going to have this easy go. Correct?
I'll place the complete instruction, Malad.
All right.
Obliged.
And give a copy in advance if you're filing an affidavit to her.
Yes, Malad.
And whom are you appearing for?
I have tried to tell my friend n number of times that we are complying with all the directions which have been issued.
Again, this
We are Kendriya Vidyalaya Sangathan, Your Lordships. We have been complying with the directions.
We are not concerned with Kendriya. We are not concerned with a particular
We have our
organization.
web portal. Everything is as per the compliance of what my.
Kendriya Vidyalaya Sangathan is, there are few in number. So they would not be asking for this. What we are interested in is all unaided schools running in the state of Assam.
She had made us a party.
No, Lordship, as per the
All right,
rules,
so therefore we wanted to know who do you represent. Kendriya Vidyalaya Sangathan, all right, they have to.
14 and 24.
They have to. That's a big,
Big organization.
those schools, they run under a big umbrella. No, we are concerned with these, schools which have mushroomed. They have got their affiliation. Even if they are unaided, they need to be affiliated with the board. And for that, they have to follow what the state says, what is the policy.
much obliged, Lordship.
Obliged.
All right.
Item 35.
We have tried to be as less abrasive as we could be, Mr. Khatniar.
I understand, Malad.
35.
May it pleases your lordship. Lordship, my senior has recently been entrusted with this
Let us
matter.
see what is the matter. Yeah,
Yes. What happened to that election? Not yet.
Election of 10th.
Society review dismissed. Appeal dismissed, review dismissed.
When the appeal was filed, we had taken the liberty to go back to the learned review court. In the review court, the learned single judge did not proceed.
So, Mr. Bonik, at the end of the day, the question is whether new election is held. Or the society is running like without anything. Who is running the society?
They are manning it up, the officials, because the elections.
Who leads you? Mr. Bordolai? Where is he?
I'm here.
Oh, so you are here. Yes. Tell us what is the words. Notice for convening meeting of the court. Where is the judgment? Let us see the review judgment.
Page 16, million, 16.
Just give us a minute. And where is the order, original order?
That my lord finds at page 33 starts.
Page 1?
Page 33.
No.
That no. It is for 2024 order.
No.
Single judge, 150.
Yes, that's at 33. Page 33.
Page 33.
33.
There. It has this code of then what happened? What has happened pursuant to this? You're supposed to convene, no?
Lordship, otherwise, as on date, your Lordship, the one-man committee is running the affairs of the society.
90 days have not passed.
It has passed, Your Lordship.
Then
But the elections were not conducted due
who
to
appears for the registrar? Is he a party here?
IAP.
So then what is he doing now? He has to convene the meeting, no?
Lodge.
Then
That has not been done because of dependency of this appeal, Your Lordship.
no, we dispose. Yes, Mr. Pani. No, sorry, we did not hear you.
No, it's okay, perfect.
Sorry, Mr. Pani.
No, I understand where I stand, but again,
Revive that, otherwise you cannot revive.
Look at this. Now we are unnecessarily going into all that.
Mm.
Now the review order does not appear to be incorrect to us. Absolutely correct. You are whipping the old odds, dead odds. You want the matter to be reheard. You wanted the matter to be reheard. It was rejected, right?
we pointed out only one thing, that the documents which were
Those
not
two
there,
documents were supposed to be in your cognizance if you were diligent.
but it came suddenly. So no one had it actually. No one had it suddenly. So that's what we say.
You know the law.
He knows them.
But it was there.
My brother says that Mr. Panik knows the law. You know the law, but you're not appreciating it.
No, I am.
Now, if there is any, we would have passed an order directing the registrar to, the one-man committee to do the needful, but we have not been called upon to do that.
Only thing is that, Milord, the ground on which the writ petition was rejected, the review was that we had the documents, we could not place that. But the Honorable Single Judge did not take into account that.
Take it. We have heard Mr. Manik, learned advocate for the appellant, and Mr. Mr. So for respond number?
All the respondents, Your Lordship, they were co-person department. Co-person department.
Except one. The private respondent has been served.
Be more specific when we are not at the memo of parties page.
1, 2, 3.
Except one.
No, except number 4.
1, 2, 3, Your Lordship, I appear.
He appeared before his.
Four is served.
Private respondent.
Response number 1 to 3. Nobody has appeared on behalf of respondent number 4 who has already been served notice. Several writ petitions were filed against the order passed by the registrar against the automatic distribution of the board of directors of Ibru Dangari River Part 1 Mean Sambe Samiti Limited. Yeah. The learned single judge of this court, while deciding such writ petitions, recorded that on 30/9/2023, for the operation of the provisions contained in Section 39 of the Assam Cooperative Societies Act 2007. What did I say? Okay. The BOD stood dissolved on and from 30/9/2023. And therefore, there was nothing for the court to decide except holding such writ petitions to be infructuous. The fact remains that 6 months had passed and there was no meeting of the board of directors. The annual general meeting was not convened. Annual general meeting of the board of directors was not convened. This order was challenged in review on the ground that AGM could not be held because of the no naming of two nominees of the government. Which document was not present before the learned single judge? While the cluster of writ petitions were decided. The review petition was dismissed on the ground that those two documents could not have been said, could not be said to have been recovered, discovered, or could not be known to the review petitioners exercising due diligence in the matter. On a plain reading of the facts of this case and the two judgments referred to above, namely the judgment passed in WPC number so and so and in the review petition referred to above, it is apparent that for whichever reason, the annual general meeting was not held, and therefore a one-man committee was constituted, which has till today been running the functions of the board of directors. In fact, 90 days have passed, but no further order has been passed only because of the pendency of the present appeal, present writ appeal questioning the correctness of the review order. Since by operation of section 39, of the Act of 2007, the board of directors to dissolve, and we finding no reason whatsoever to differ with the order passed in review, the only course open to us is to dismiss this appeal, first to ensure that the further action, further decision, further steps be taken in terms of section 41(6) of the Assam Cooperative Society. Yes.
Item 38.
Mr. Das, you have to appear, no?
No, that is different. No, that is. My item is in hearing.
Your item is in hearing.
It is
That's
something
six.
else, I suppose.
What is it for? Status of request made to him for facilitating the taking over. Yes, somebody was to tell Sumitra was to inform this court.
We are still waiting for the instructions of it.
Yes. Yes.
We are yet to have the instruction as requested by the court.
Mr. S. Barua, learned counsel for the state, seeks some more time to convey to this court about the status of the request made by the writ petitioner for facilitating the taking over of the secured property, secured/mortgaged property. Re-notify next week or 2 weeks.
Lordship, on that note, item 36.
Hearing. Yes. Brahmaputra board.
Yes.
State within Article 12, but not for the purposes of pension, gratuity. That is the only hitch. Tell us. There is no automatic extension of that circular of 2015. I think we remember the facts.
1987, yes.
1987. We
If the
remember
facts are like the Brahmatra board was established, initially all the employees came on deputation. Since those persons were already enjoying the GPF benefit in their own organization, so initially GPF was not introduced in Brahmatra board. CPF was continued. Then thereafter a decision was taken that after joining of the financial advisor, the GPF scheme will be implemented. That remain as such. In the meantime, my lord, the office memorandum of the central government came, wherein it has been provided that everyone who was CPF, who was in CPF, those will be deemed to be under the GPF.
No, that is not the circular.
No, it's there written in the circular.
No. Unless they are out. You're talking about the central government circular.
Yes.
No.
Yes, well, merit.
Not for you. All central government employees.
I'll come to that, my lord.
Okay. Yes.
I'll come to that, my lord. But what is the core of the circular? That I have to explain, because this circular has been discussed in a Supreme Court judgment, my lord, in Sasikiran's judgment, 2022, my lord. My lord, it says all CPF beneficiaries in service on so and so should be deemed to have come over to the pension scheme on that date, unless they specifically opt out to continue under the CPF.
We remember that.
Yes. So it was the stipulation in the circular was that all CPF employees, they will be deemed to be covered under the.
We are unnecessarily taking us to that history. We will hear you, but first you tell us. Now, two things are there.
Two questions lordships raised, basically. Basically, one question that it is only for the central government employees. That question has been answered by the Honorable Supreme Court. In fact, they themselves have diluted that question because they have extended this to all, my lord, autonomous council, universities.
Correct.
So that question.
If you're asking me to go through Ajay Hasia and all that, it's not necessary. See, that definition, that extension of the definition, that wider, some instrumentality, agency, under a statute, by a statute, all this we know.
No, I'm not on that, my lord. What I'm trying to convey is that, my lord, I'm sorry, my lord. Lordship's question was that in the OM, it was mentioned that central government employees. So Brahmatra board is not a central government employee.
That's not
the employees of the Brahmatra board.
You're saying that now the situation is this, that even autonomous councils and everything, wherever there is an agency or instrumentality of the state, more than 50%, less than 50%, it should be considered to be a state within the meaning of Article 2.
No,
agreed.
No, I'm not saying that.
So what are you saying then?
What I am saying is that they have extended this benefit to IIT, Bombay, IGNO, IIM, Lucknow.
Aren't you making self-goal?
No.
You are. Because it is specifically extended to these organizations. It has not been extended to you. That is the basic challenge. That is the basic challenge of Mr.
That question arose in the Sasikiran's case. Yes, madam. 2022, this will
answer says that there is
discriminatory
automatic extension.
Yes. That's why I wanted this to produce, because this will answer many of the queries of your lordship.
Sure.
The Honorable Apex Court has said that you have extended.
Show us the paragraphs. First, you tell us the University of Delhi. What was the issue there?
My lord, therein also the issue was implementation of this particular circular. There were three.
The same circular.
Same circular.
Of 87.
87.
Okay.
There were three batches of writ petitioners. Some, my lord, gave option. Some did not give option. Some gave option in the extended date. All these came before the Delhi High Court. Delhi High Court single judge allowed. Then division bench, my lord, interfered with one batch of petitioners, that is the Sasikiran one. Then finally went to Supreme Court, my lord. Then Honorable Apex Court decided by relying on another judgment of Supreme Court, that is S.L. Verma, reported in, my lord, 2006-12 SCC 53.
You'll find it here. No?
Yeah, that reference is there, my lord. The Honorable Apex Court said that so far as circular is concerned, there is a deeming provision. Whoever in the CPF, they'll automatically come over to the GPF account.
Read that paragraph which says so. No extension order is required. Automatic deeming.
Yes, ma'am.
And that was with the choice inter C, whether it was discussed that it was extended to universities also. Universities otherwise, for pension, they are on the same plane.
Not only universities.
हाँ दिखाइए ना, पैराग्राफ दिखाइए.
Yes.
Where is that discussion?
Yes. I'm sorry.
Everywhere it says that these are two different procedures. Those who had not exercised but continued to make payment of contribution, those who exercised option, these are. Those who consciously exercised the option, that was inter C, the employees. Now, Sashi Kiran is not going to help you. Tell us something that for all practical purposes, whatever is admissible to a central government employee, that shall be admissible to, or that shall be applicable to employees of Brahmaputra board also, which undoubtedly is a state within the meaning of Article 12, but not for those purposes.
Para 48.
नहीं वो कहता है कि discriminatory approach किया, तो ठीक है. Because they had extended it to employees of the university. Look at this. Read the entire, you will get the answer.
Yeah.
So you should find another judgment, not this. This doesn't help you. Now read the entire paragraph 48. The answer is hidden there.
It was again these three subcategories coming from the same category of employees that the argument of discrimination.
Now let us first read those three categories from 47.1.
Those who had not exercised any option but continued to make payment of contribution towards CPF. Those who exercised the option to be under CPF, but the option was exercised after the cutoff date. Since the option was exercised after the cutoff date, they were deemed to have come over to GPF and were granted benefit. Those who consciously exercised the option to be under CPF, but taking advantage of the further options granted through 11 extensions to switch over, had been allowed to come over to GPF. It was again.
Now, what are these 11 extensions?
Lord, what happened after 1987 till coming up of the ROP rule 2006, that is implementation of the Sixth Pay Commission, they continued to give options to the employees of this organization to switch over to the GPF. This exercise continued till 2006, Milord. There is a single bench judgment of our own High Court, Milord.
Let's see paragraph 48 now.
Yes. It was again these three subcategories coming from the same category of employees that the argument of discrimination was considered by the division bench. Such was not the case in so-and-so. The matter was further considered by the division bench in the context of the employees of educational institutions, such as IITs, who are directly under the central government, just as the employees of the university, which is a central university. If the option was allowed to be exercised by granting extension to the employees of the other educational institutions.
Here is the answer.
The division.
Extension was allowed.
Other educational institutions. Because Lordship will have to go to the. There was a finding.
We want to give you that, but we must have.
May I just. There is.
Just a minute.
Perhaps
just a minute.
I'm sorry.
Yes. Now, Mr. Das, come to para 7. The facts are different.
Para 5 also.
Read para 7.
Yes.
Para 5 also you read.
Yes. Around the same time, a communication was addressed on 5587 by the central government to the registrar of the university, stating that the Honorable President of India, in his capacity as visitor of the university, was pleased to approve the proposal of the university for amending Statute 28A, giving benefits to its employees relating to GPF, CPF, gratuity, etc., which were more advantageous to the employees of the university in pursuance to similar order issued by the central government with respect to their own employees. The amended statute.
Now you read that.
Yes.
Paragraph 7 now.
Yes. Close on the heels, a notification issued by the university on so-and-so stating that all the CPF beneficiaries in service on so-and-so would be deemed to have come over to GPF under statute
this was
so-and-so.
extended to university.
That same exercise was done in our case also. That's why they have 950 employees submitted option. Option were asked from us.
Deeming provision.
And it's a deeming provision. Shashi Kiran.
Mr. Mr.
No,
Chaudhary. I was remembering DK. Mr. RKD Chaudhary, tell us. Here it was only deeming provision. Now, can you say that there was a extension to Delhi University? It was only by virtue of that OM of 1987. It was deemed to be extended to central government. Delhi University, which is a central government.
Now, those were the cases where they were governed by the CPF rules. Here, so far as the
Not on that. First, tell us first point.
Yes.
First flashpoint is this. You say, and we also think like that now, that there cannot be any automatic extension, not the deemed provision, but here it is deemed. So unless you say that for Delhi University, it was said that all central government universities will be, this OM would be applicable. There must have been some extension somewhere.
In so,
No, therefore deeming, no.
Original was 85 central government.
तो पुराना उसको लेकिन कहाँ है this 87
87
cutoff date है that's a cutoff date. Close to the ends, the notification was used by the university stating that all sit. Again, ठीक है, that was there from him.
It was already 85.
उसके बाद extension kept on granting extensions. They of their own started granting extensions because there was no dispute. Here there is a dispute.
No,
They
this
say that we
extent,
will not-
there is
They say that we will not do it to you. Brahmaputra Port.
Sorry, Miller.
They say that it will not be applicable to Brahmaputra Port. There, the Delhi University itself treating it as deeming provision. They kept on giving extensions for filing.
No. Deeming provision is not for extension. Deeming provision is the soul of that particular circular.
They followed.
Its extension did not came because of the deeming provision.
This was never questioned that can it be extended.
They
take first there it was not denied. For Delhi University, switchover was not denied by the central government. Here it is denied. It is said that no, we don't want.
No, how can they deny, Milord?
They can because it is basically a work charge establishment.
No, Milord.
Yes.
It's
Yes,
grants in
yes,
aid.
yes.
No. Milord, then what happened to, all right, Milord, what happened to IIT? What happened to IGNO? IIM Lucknow?
You can't compare yourself with IT.
No, then Assam, no. Milord, there is a single bench judgment of this honorable court, Itanagar bench, same issue decided, Milord, that Lordship will kindly have a look, Milord.
Pending in appeal, division bench.
That is, I know, Milord. Milord,
We will decide that appeal also.
And the next,
We will decide
the
that.
next
What is the status
submission,
of that?
the next submission I was supposed to make before your lordships that this judgment is under appeal, read appeal number so and so, Milord.
Like, that will come before us only.
No, it is pertaining to Arunachal bench, lordship can bring, Milord. Read appeal number, my lord, 38/22. as because they have conferred the benefit, that's why 950 employees submitted the option.
Only clear.
Perhaps Lord would like to, my lord, go through Sasikiran.
During the course of argument. To recapitulate the facts, in short, the issue raised in this appeal is whether the issue which has been raised in this appeal is whether the office memorandum dated 1/5/1985.
1/5/1987.
Office memorandum dated 1/5/1987 brought out by the Ministry of Personnel, Public Grievance, Pensions, Department of Pension and Pensioners Welfare, Government of India, with respect to a changeover of the central government employees from contributory provident fund scheme to pension scheme in connection with the implementation of the recommendations of the Fourth Central Pay Commission would be extendable to the employees of the Brahmaputra Board, a statutory body established by an act of parliament.
Lord, with all due respect, my lord, I'm extremely sorry. Lord, the issue is not that extendable. The issue is it has already been extended, and pursuant to that extension, 950 employees submitted their option. Can they now deny that?
Where is that extension?
Option. Yes, the letter seeking option I have annexed.
So we have found out that this is the issue.
Fine, fine.
We have found out that this is the
fine.
You may apply, you may say, yes, I go, you may pass a resolution of the board. Does it make it function?
I'm all right, I'll satisfy.
The issue is this only. A prima facie view was taken on the earlier occasion by this court that Brahmaputra Board, being a statutory body established by the Act of Parliament, no doubt would be a state within the meaning of Article 12 of the Constitution of India. But the benefits extended to central government employees may not be applicable ipso facto to the employees of the Brahmaputra Board without the same privilege being specifically extended to such employees. Countering such argument, Mr. H.K. Das, learned advocate, has pointed out that by the judgment passed by a learned single judge in the Itanagar bench, it was decided that by deeming fiction, any benefit extended to central government employees, especially with respect to pensionary benefits or a right to elect between GPF or CPF, would be extendable to employees of the central government undertaking, employees of the central government undertaking. That judgment, Mr. Das has fairly stated before us, passed in WPC number 400 of 2015, has been appealed against, which is pending consideration. Let this case be placed before the Chief Justice on the administrative side for aligning the aforementioned appeal along with the present appeal for hearing.
Read appeal, my lord, 38/2022.
Formally, the writ appeal number so. And await, so we will pass an order and we'll have it listed on.
Fine, my lord, no problem. But only one small, just my understanding, my lord, of your lordship's order. The learned single judge, my lord, did not decide granting of benefit on the basis of deeming provision.
Or this may
Because
create,
this order,
it
lordship
may-
will read in the next time.
it may create confusion. You are absolutely right.
So
What did I say about it?
it said that on the ground.
You are
of
absolutely right, Mr. Das. Where I understand the folly, we will immediately rectify.
I'm sorry.
What did I say?
Mr. Dutt pointed out that by the document passed by
In WP number so and so. In WPC number 400, 2000, it was decided. No, it was decided that the the applicability that the provisions of the OM of 1985 would be applicable.
Para 21 onwards.
Just a minute. Let's see the response. Would be applicable to what is that organization?
This is nearest, my lord. Any other,
We would not know.
that is Northeastern Regional Institute of Science and Technology.
Northeastern so and so.
Regional Institute of Science and Technology.
This. And then the next line of appeal that has been.
Lordship.
You're right. You will draw a parallel that in that case also option was given. This option was of their own. They came out with an option.
No, it cannot be. How can it be, my lord? It
No.
cannot be. My lord, I'll request your lordship will go through Sashikiran once, my lord, because it's a lengthy judgment, my lord.
All right, we will see.
I'll satisfy, my lord. I'll satisfy.
Before the administrative side. And only thereafter, this appeal shall be listed for hearing.
Did it?
Anything else?